You transferred your home into a trust, you paid it off completely, and you were confident your children were safe. But in 2026, the government holds a legal mechanism that allows it to claim that property regardless. And the attorney who created that trust more than likely never brought it up. This is not a theoretical scenario. In the past year alone, states throughout this country recovered $700 million from the estates of seniors who had received Medicaid-funded long-term care. $700 million. The majority of those families had paperwork in order. Many of them had trusts established, and almost none of them had any warning until a legal notice arrived after their loved one had already passed away. If your home is fully paid off and currently sitting inside a trust, stay with me for the next 12 minutes. Because what I am about to walk you through is the precise trap that thousands of families step directly into every single year. My name is Lana Maines. I work to represent taxpayers directly before the Internal Revenue Service. The pattern I encounter is always identical. The trust was in place. The protection was not. Here is where the false confidence begins. Most seniors who transfer their home into a revocable living trust operate under the belief that the asset is now shielded from outside claims. It is not. A revocable living trust is completely transparent in the eyes of Medicaid. You continue to hold control over the asset, which means that under federal law, Medicaid still treats it as belonging to you. The state can see it clearly. The state can pursue a claim against it following your death. The word revocable is precisely where the problem lives. Revocable means you retain the ability to reclaim that asset whenever you choose. And because that option remains open to you, the government treats the situation as though you never transferred ownership in the first place. That is the most financially damaging misunderstanding that exists in elder law today, and it is entirely invisible when it happens. There is no notification issued when you execute the trust documents. There is no disclosure on the Medicaid application. There is simply a home your family believes is protected and a legal claim quietly waiting to be filed against it. The reason so many families fall into this situation is straightforward. The attorney who created the trust was an estate planning attorney, not an elder law specialist. Those are not the same professional credential. And the distinction between them is frequently the difference between a home that remains in the family and one that does not. If you are a lower-income senior, your home is most likely your only significant financial asset, which makes this the most pressing concern on this entire list. If you are a more comfortable retiree with savings and a pension in place, you may believe this situation only affects people who have depleted everything they had. That assumption is incorrect. Medicaid planning can be structured legally across a broad range of financial circumstances. You will never hear that from the caseworker at the nursing facility. That leads directly into the federal law that most families have never encountered, because this is not a state-level program that individual governors choose to operate. It is a federal mandate. Under the Omnibus Budget Reconciliation Act of 1993, every state in the country is legally obligated to pursue estate recovery against the property of Medicaid recipients who were 55 years of age or older at the time they received those benefits. Legally obligated, not optional, not left to individual discretion. Every single state must carry this out. The nursing facility did not bring it up. The Medicaid caseworker did not bring it up. The intake coordinator at the state office did not bring it up. Never mentioned, never disclosed, never volunteered under any circumstances. And the reason it is never volunteered is entirely simple. The state holds a direct financial interest in recovering that money. And explaining the strategies that prevent recovery is not part of anyone's job description at the Medicaid office. For the lower-income senior who entered a nursing home under Medicaid coverage, this law means the state holds a legal claim against your estate beginning on the very first day of care. For the comfortable retiree who is certain their family will never need Medicaid, consider that nursing home costs currently range between $9,000 and $11,000 every month. A 3-year stay generates a recovery exposure exceeding $324,000. A 5-year stay pushes past $660,000. Savings that once seemed more than sufficient can be completely exhausted far faster than any family anticipates. When that happens, Medicaid becomes a necessity regardless of how carefully a family had previously planned, and the recovery program activates from the very first day of coverage. That leads directly into the real-life case that illustrates precisely how this unfolds. Patricia is a 71-year-old retired bank teller from Knoxville, Tennessee. Her home was completely paid off. No mortgage, no lien, no debt of any kind connected to the property. Her daughter had engaged an estate planning attorney years before. That attorney established a revocable living trust. Patricia's home was placed inside the trust. The family felt secure. They had formal documentation. They had retained an attorney. They believed they had done everything they were supposed to do. Patricia was diagnosed with dementia at the age of 74. She was admitted to a skilled nursing facility. Medicaid covered the full cost of her care across the following 4 years. The family visited consistently throughout that time. They managed her affairs, handled her bills, and processed every piece of paperwork the state requested. Through all of it, they remained confident that the trust was doing exactly what it was created to do because not one person had ever indicated otherwise. 14 months after Patricia passed away, her daughter received a formal legal notice. The state of Tennessee had filed a recovery claim against Patricia's estate in the amount of $227,000, representing the total Medicaid expenditures that had been paid on her behalf. The home was the estate. The trust was revocable. The state had been able to see it the entire time. The attorney who drafted the trust never raised the possibility that this could occur. The Medicaid office never raised it. The nursing home admissions coordinator never said a single word about it. The $227,000 claim arrived inside an envelope 14 months after the funeral as the first indication the family had ever received that any of this was even a possibility. Patricia did nothing wrong. She followed every piece of advice she had been given. That advice was incomplete, and that incomplete advice ultimately cost her family $227,000. Right now, stop and retrieve the trust document for your home or for your parents' home if that is the situation that applies to you. Turn to the first page. Locate the word revocable or irrevocable. That single word will tell you whether you have genuine legal protection or a document that provides none whatsoever. Look at it right now because everything that follows in this video depends entirely on which word appears there. That leads into why 2026 has made this situation more urgent than it has ever been before. States are broadening the definition of assets subject to Medicaid recovery to include what the law refers to as non-probate assets. Non-probate assets are assets that transfer ownership outside of a will, including assets held inside certain types of trusts. 27 states are currently operating under these expanded recovery rules. In those states, a trust that would have been invisible to recovery claims in 2020 may now fall squarely within reach. The regulatory direction points only one way: more recovery, not less, and more categories of assets falling within reach with every passing year. The second critical factor is the 5-year look-back window. Under federal Medicaid law, any asset transfer you execute today remains visible to Medicaid for a full 5 years. A strategy implemented in 2026 begins providing meaningful protection in 2031, provided no care need arises during that interval. Families who delay action until a medical crisis has already arrived do not have access to most of these protections. The window exists right now. That is the only moment it is open. 5 years from today, the clock you start today will have completed its run. 5 years from today, without action taken now, you will be standing in exactly the same position Patricia's family found themselves in. That is the legal framework. Here are the 6 protections that can actually provide meaningful coverage. Protection 1 is the Irrevocable Medicaid Asset Protection Trust, commonly referred to as a MAPT. Unlike a revocable trust, an irrevocable trust removes the asset from your legal ownership entirely. You no longer exercise control over it because you no longer hold the ability to reclaim it. Medicaid cannot count it among your assets. The rule that governs everything here is timing. The transfer into a MAPT must take place at least 5 full years before you submit a Medicaid application. Fund it today and apply in year 6, and the asset is fully protected. Fund it today and apply in year 3, and the transfer carries a financial penalty. Timing is the entire mechanism upon which this protection operates. You retain the legal right to remain living in the home for the remainder of your life through a specific provision built into the trust document. Your children or designated beneficiaries receive ownership at the time of your death. The home continues to function in daily life exactly as it always has. The difference is that it now resides within a legal structure that Medicaid cannot reach. The cost of establishing a MAPT through an elder law attorney typically falls between $2,000 and $4,000, measured against a potential recovery claim of $200,000 or more. That investment carries one of the clearest cost-to-benefit ratios in the entire field of legal planning. Protection 2 is the Lady Bird Deed, previously referred to as an Enhanced Life Estate Deed. This legal instrument allows you to retain full control and unrestricted use of your home throughout your lifetime, while automatically transferring ownership to your named beneficiaries at the moment of your death entirely outside of the probate process. In the states that recognize this instrument, a ladybird deed removes the home from your probate estate, which limits the state's ability to pursue recovery under standard estate recovery rules. It is not available in every state, and it functions most effectively when used alongside a MAPT rather than as an independent strategy standing on its own. Protection 3 is the Spousal Protection Transfer. Federal Medicaid law provides specific and defined protections for a community spouse, meaning the spouse who remains living at home while the other receives nursing home care. The home itself is generally treated as exempt from recovery during the lifetime of the community spouse. The trap that repeatedly catches families off guard is the following. That exemption ends the moment the community spouse passes away. At that point, the state moves forward with its recovery claim against the home that was protected while the spouse remained alive. Families who believe the death of the surviving spouse eliminates the risk entirely are mistaken. It is precisely what triggers the claim to be filed. The correct approach is to use that protected window of time to establish a MAPT while recovery is temporarily deferred. When these two strategies are used in combination, they can deliver complete generational protection for a fully paid-off home. So here is what I want you to do. The exemptions, the reductions, the refunds that most seniors already qualify for but have never claimed, I have gathered all of them in a single resource organized by state and by specific form, so you are not spending hours searching through government websites trying to find relevant information. Everything is presented clearly and simply so that any senior can identify precisely what applies to their individual situation. Regardless of which state you live in, there is money being left unclaimed. It is called the Senior Exemption Playbook. You will find it in the first pinned comment directly below this video. Simply tap it once and you will have everything you need in front of you. Now stay right here, because the final protection I am about to cover is the one that most seniors never use in time, and it is the primary reason I created this entire video. Protection 4 is the Caregiver Child Exemption. Under federal Medicaid rules, a home can be transferred to an adult child who resided in that home for a minimum of 2 years prior to the parent's admission to a nursing facility and who provided care during that period that demonstrably delayed the need for institutionalization. If those specific conditions are satisfied, the transfer is exempt from financial penalty and exempt from recovery claims. The child must have genuinely lived inside the home, not simply visited on a frequent basis. The care provided must cover the 2-year period directly preceding nursing home placement, not 2 years at some earlier point in time. And that care must be documentable through medical records or written statements from a physician confirming that the parent would have required a facility placement sooner had that care not been provided. This is among the most powerful protections available and simultaneously among the least disclosed. Medicaid caseworkers are not obligated to volunteer this information. The overwhelming majority do not. Protection 5 is the Sibling Equity Exemption. Under federal Medicaid rules, if a sibling of the senior holds any ownership interest in the family home and has been residing there for a minimum of 1 year before the senior was admitted to a nursing facility, that sibling's share of the home is protected from state recovery. The senior's portion of the home can be transferred to that sibling without triggering a Medicaid penalty. This applies most frequently in families where siblings have been sharing a residence and one of them requires nursing home care while the other continues living in the home. If this circumstance applies to your family, even in partial form, a conversation with an elder law attorney can determine whether this exemption provides protection for the property. Protection 6 is the Hardship Waiver. This is the protection that becomes relevant when none of the advanced planning strategies were put in place in time and the family is now confronting an active recovery claim. Every state Medicaid estate recovery program is required under federal law to maintain a hardship waiver process. This process allows the estate or surviving family members to apply for a reduction or complete elimination of the recovery claim based on documented financial hardship. Federal guidelines identify several qualifying categories. The home represents the sole income-producing asset belonging to the estate. The recovery would leave heirs themselves eligible for public assistance, or a dependent family member has been residing in the home with no alternative housing available to them. Hardship waivers are not issued automatically, and they are not simple to obtain, but they have been granted in real cases. Patricia's family submitted one. The state agreed to accept a significantly reduced amount compared to the original $227,000 claim. It was not a complete resolution, but it was considerably better than paying the full amount without any challenge whatsoever. If you are currently facing a recovery claim, do not pay it without question and do not disregard it. Contact a licensed elder law attorney without delay and ask specifically about the hardship waiver process that applies in your state. Here is the number that places everything I have covered into clear perspective. Proper elder law structuring costs between $2,000 and $4,000 in professional attorney fees. The recovery claim in Patricia's situation totaled $227,000. In a scenario involving a $600,000 home, states have filed recovery claims exceeding $480,000. Leaving heirs with approximately 12 cents for every dollar of value the property held. That is the true cost of not taking action. The $700 million the government recovered in the past year came from families who did not possess the knowledge you now hold. The home you worked your entire life to pay off does not have to become another recovery statistic. The strategies exist. The window to implement them is open right now. Step 1. Locate your current trust document and identify the exact word revocable or irrevocable on the first page. Step 2. Search your state name combined with the phrase Medicaid Estate Recovery Program on the official state government website to confirm whether your state is operating under expanded recovery rules. Step 3. Gather 3 categories of documents before you make any phone calls: your deed, your current trust document, and any Medicaid or insurance correspondence that is currently on file. Step 4. Contact a licensed elder law attorney, not a general estate planning attorney, by searching your state bar association combined with the terms elder law and certified specialist. Step 5. Ask specifically about the Irrevocable Medicaid Asset Protection Trust, whether your state recognizes the Ladybird deed, and where your situation currently stands within the 5-year look-back window. Step 6. Take action this month, not simply this year. The look-back clock begins running on the day the trust is funded, not on the day you first consider making the appointment.